Now, I don't want to turn this into a referendum on the death penalty, but what are your feelings about prosecuting 17-year-olds for murder, considering all we know about the development of the brain, the ability to form certain types of intent, etc.?
Michael, this is a sad case. I agree, but I'm sad because of the victim, that young man, Donaldson. It was such a terrible, heartbreaking 911 call to hear. And that's what I care about. This is someone who, yeah, he was 17, but he's certainly not 17 now. He took a gun to a drug deal with the intent of committing robbery. And not only did that, he shot and killed the victim in the chest in cold blood. So this was absolutely premeditated. This is absolutely someone that had the intent to kill, or certainly felony murder. And whether it's a death penalty case or not, 25 to 30 years is a significant discount. Frankly, it's charity for someone that I don't think deserves it. So if he doesn't take this deal like he should, like his attorneys are advising him to, if and when he's convicted at trial, because believe me, Michael, he will be convicted. There's cell phone evidence, there's multiple eyewitnesses, there's a cooperating defendant. It's not a matter of if, it's a matter of when. I expect a significantly higher sentence after trial for this particular individual, Mr. Everett.
Certain claims, the state has others. I want to go through those. So we just talked about the one that the defense is claiming that Rosenbaum was actually attacking him, and that they want to bring in this information about his past, about being a sex offender, and that plays into their narrative. I want to get your thoughts on that idea. I've seen some cases lately, in self-defense cases, where the state of mind of the person attacking the defendant in the case has become a real issue.
Michael, you hit it on the head. Jockeying is right, because there is zero chance any judge in this country is going to allow evidence of Rosenbaum's status as a sex offender. There is no evidence whatsoever that Rittenhouse knew who Rosenbaum was, much less that he knew he was a sex offender or that he shouldn't have a firearm. This is just another effort by the defense team to dirty up the victims in the case, play this case out politically. We know they're pandering to gun rights advocates and, all lives matter folks, or even white supremacists. And there's no question that this case is going to go to trial, whether it's in November or it's continued sometimes later, because this is a self-defense case. But I'm really ashamed of the attorneys here on the Rittenhouse side, because they constantly try this case out in the media and try to get public attention and sympathy for Rittenhouse, who frankly is someone who murdered two innocent people, one of which was attacking him with a plastic bag.
Something that they're trying to put out there in the court of public opinion is they want to introduce evidence of him and his affiliation with the Proud Boys. Now, we know there were some photos of him taken after his initial arrest in a bar with people who they claim are part of the Proud Boys. In fact, one of the leaders of the Proud Boys they're claiming is in those photos. What do you think the chances of them getting that in is?
I think that's unlikely, especially because most of that conduct or misconduct was after he was arrested and he bonded out. I didn't see any evidence of him being affiliated with white supremacist groups or Proud Boys before the events in Kenosha. With respect to the assault on the teenage girl, I think there's a possibility it does get in. The defense can open the door with a self-defense argument if they get up there and they say the wrong things, and if they specifically say that Kyle Rittenhouse is a peaceful person, then the state can come in and potentially bring some of that evidence in on rebuttal. So something the defense has to be worried about, and I agree with what Kirk said. I mean, this is all playing to the potential jurors in this case, and if the state can successfully get that evidence in of someone who is assaulting a young woman, that's going to be helpful for the state's case. And if miraculously they can get this Proud Boys evidence, and I don't think it will come in, then that's something that jurors are not going to like at all.
I was wondering why there wasn't a deal here. If there was this DNA situation, that they may be waiting to find out if they can get that DNA tossed before actually getting into serious talks. But the state says they will not accept anything that doesn't include jail time. That sounds right to me.
I agree, Michael, nor should they. I mean, this is a woman who was raped, someone who is intellectually disabled since she was 3 years old. She has no use of her limbs. These are the folks that our society needs to protect more than anyone. And Sutherland's job was to do so. But what did he do? He sexually assaulted her instead. So I understand why he's making this legal argument, because frankly, there is no argument on the merits. He is the father of this child. He raped this woman. His only shot is to get this DNA evidence suppressed, but it's unlikely. Courts have routinely held that you don't need probable cause to get a DNA sample. Happens in family court all the time or different talk shows. Well, obviously, that's not court. So what he's arguing would certainly be novel if it were accepted by any appellate court. It's certainly been rejected by the trial court, but really, it's the only defense in this case, a legal argument that would suppress this DNA. Otherwise, he is going to jail.
Try just about everything. This is another try on their part. But I want to ask you something else. I want to talk about these agreements. The one we saw like in the Cosby case by Castor, the one we're talking about here. I can't get out of my mind that they're both made with either someone with a lot of money, well, a ridiculous amount of money, more than any of us will ever see or probably can't even understand, and someone who's very famous, has a high profile. What do you think about these types of agreements?
Michael, I absolutely hate them. What Bruce Castor did, which I still disagree was an agreement. I mean, we're a week away from the Bill Cosby miscarriage of justice, that opinion that came out. But what Alex Acosta did when he was U.S. attorney in Miami was absolutely shameful. To give a sex trafficker like Epstein a non-prosecution agreement, which actually is an agreement, was beyond shameful, and sentence him to or have him do state time. I mean, just unbelievable. I could tell you, I put more than 1,000 people in prison as a federal prosecutor. I never gave one non-prosecution agreement, but I've read a lot of them, and I agree with Eklund. They are limited to the parties to the agreement, and that's it. You know, they don't cover other people, and they certainly don't cover other jurisdictions. It's crystal clear that they only bind that U.S. Attorney's Office. So that would be the Southern District of Florida and Miami. They do not bind the U.S. Attorney's Office in New York. This is an argument by the defense, just like the repeated bail motions, but certainly not a good one.
Each case separately. And Neama, you know, I get her point, but at the end of the day, you know, precedent is a big thing. And, you know, if she can prove somehow that there is some nexus between her and this agreement, there was some form of reliance, she may find herself in a similar position.
She may, Michael. That's why last week's case was so unprecedented and frankly opened the door to all these arguments. I expect to see a lot of these defense motions in the future.
All right. Thanks, guys. I truly appreciate you.